Hello there, Thunder Government students. Let me go ahead and hopefully get my screen to the top right there. A little bit of a screencast here of me walking and talking you through notes introducing you to our American judicial system. Talking about, in general, the participants inside of our American judicial system, and then ultimately two of the major types of law, okay? I'm going to sprinkle in a little bit of the textbook material from 7.1 as we cover this as well, all right? For the most part, though, 7.1 touches on some items that we are going to see through these keynote slides, and also some items that we're going to see when we start talking about Supreme Court, and we start talking about, in general, the structure of the national court system and how state systems, county systems mimic that structure, okay? In short, all right, our American judicial system is built on the concept of adversity. It's adversarial, right? The conflict theory of law, if you will, where you pit two opposing sides against each other. They both share their narrative, their story, their body of evidence, their explanations, their facts, their truths. And then you have an impartial referee, i.e. a judge, and an impartial jury, somebody to sit back, listen to both sides, and ultimately render what is or is not true. The two sides we commonly refer to as the prosecution and the defense. The prosecution, for the most part, representing the party, the individual or the entity or the group of individuals, okay? The prosecution representing the party that's trying to uphold the law or is accusing somebody of doing something. The defense, all right, or the defendant, that would be the individual with their legal counsel, their representation, looking to provide their story on why they should not be convicted of the accusations brought against them. So this adversarial system, okay, built off the conflict theory of law, is all about getting the truth to emerge through opposing forces inside of a courtroom or a similar setting where you have somebody that's officiating or refereeing the process, i.e. a judge, and then an impartial, unbiased panel of peers, of individuals that are going to render a verdict. Simply put, if we were to make it into a mathematic formula, it would be prosecution plus defense equals or yields justice, right? And remember, way back at the beginning of the school year, we talked about justice, big major concept ideas of what justice is, okay? Ultimately, that's what we are yearning for, and our American judicial system is envied around the world, okay? Is it perfect? Absolutely not. Absolutely not. But more often than not, we have a system where we protect those that have been accused. More often than not, in the court of law, their rights are not trampled upon, and justice is served more often than not. Some basic judicial concepts. Hinted towards a couple of these already on the previous slide. The accused or the defense. You're always innocent until proven guilty. This is huge in the court of law. This is enormous in our American judicial system. Unfortunately, with the 24-hour news cycle, social media, everybody following every single thing, you're not always innocent until proven guilty in the court of public opinion, right? That's why you can typically have accusations brought upon somebody, and within hours, everybody's already got their opinion, right? Everybody already has raced to judgment of the situation, and we haven't even had a full investigation. We haven't even afforded that individual their day in court. So it's paramount in the American judicial system when we actually get down to the law itself and whether we are or not going to convict somebody, that the accused are assumed innocent until proven guilty, no matter how trivial or heinous the act may be. Also, the burden of proof rests on the prosecution. So the individuals that are bringing the accusation upon the accused and looking to try and convict that individual, to get a jury of his or her peers to say, yes, we believe they did do what you're accusing him of. That burden of proof to sway the jury to prosecute, to convict. All right, that rests with the prosecution. You yourself don't have to, provide as a defendant information that is incriminating. We covered a little bit of this when we went over some of the Bill of Rights and the amendments. The American system, no surprise, modeled after the British system, deeply embedded with natural law, and fundamentally, our American judicial system protects three things: life, liberty, and property. Life, liberty, getting the camera there, property. All right. The Eighth Amendment, the Fifth, Sixth, and Eighth Amendments, and the Fourth and Seventh Amendments, all items that we've gone over. Again, historically speaking, the vast amount of court cases, whether they be criminal or civil, are going to revolve around those three things. So that does it with this first little subsection, Introduction to the American Judicial System. I'm going to cut it off there. That way, in case you want to kind of go through this early portion of the notes, you can kind of go just one at a time, all right? The introduction here, the participants, and then the law itself. So we'll pick it up in the next little video with the participants and the legal system. Later.